Hi, I'm Sam Light, Deputy Executive Director and General Counsel at CIRSA. Congratulations on your election or appointment to public office. I hope you find your time in local government to be an exciting and rewarding opportunity to work with your fellow public officials to serve your community. The purpose of this CIRSA video is to help you avoid mistakes that can lead to liability and identify some best practices that will reduce your liability risks for you and your organization and enable your success as an elected official. As you know, citizens expect transparency from their elected officials, and it's required by law. Therefore, you'll want to make sure you're familiar with and are following the openness requirements of the Colorado Open Meetings Law, as well as any local rules of your organization. The Colorado Open Meetings Law states that any discussion of public business among 3 or more of your governing body members, whether in person or by phone, email, or other electronic means, must occur at a meeting open to the public.
I think between the 3 of us council members, this deal's a home run. We all agree? Great.
That's illegal procedure. In addition, closed executive sessions may be held only for a very limited number of specific topics and only in compliance with detailed executive session procedures. We suggest you have staff support and a script available for any proposed executive session. There are significant liability risks in this area, so make sure your systems are set up to comply with the legal requirements governing the call and conduct of executive sessions and to protect confidential information belonging to your organization.
Hey, Cheryl, come in here. So we had this wild executive session yesterday. Technically, I'm not supposed to talk about it, but let me tell you all about it. So Gary comes in, and he's got this top secret pile of, documents, and he's got a big, long black trench coat on, black hat. He's like sneaking around, he's putting the collar up. It was just perfect.
That's a foul. Violations of the Open Meetings Law can lead to legal claims against your organization and result in significant disruption and costs.
Council members Smith and Jones, thank you so much for jumping on this call today. I love these ideas. Let's just hope we can push them past the public, huh?
Violations also will undoubtedly erode faith and trust in your leadership. Therefore, recognize your obligation individually and collectively to honor the openness requirement of the Open Meetings Law. Avoid any conduct that can spur accusations that your meetings are merely rubber stamping decisions already made. By honoring the spirit and intent of the Open Meetings Law and the other laws of transparency, you will build citizen faith and trust and reduce your risk of liabilities. If you're like many elected or appointed officials, you probably see your role first and foremost as being a policymaker, as someone who brings their own ideas and perspectives to your board's or council's discussions of the important policy issues facing your community. In this role, you advocate for your own views, you lobby your fellow elected officials, and are lobbied by citizens, and you even research and develop your own ideas on policy issues. In short, in this role, you do the things that legislators do. But being a legislator is only part of the job. At other times, you and your fellow board or council members make decisions affecting the property rights of individual applicants, and this role requires you to conduct yourself like a judge. In this role, you are making what the law calls quasi-judicial decisions, where you have an obligation to ensure due process. You must conduct yourself according to the constitutional requirement that, quote, no person shall be deprived of life, liberty, or property without due process of the law. What does this mean specifically for you? You must act like a judge and do the things that judges would do and not do the things that judges wouldn't do.
What happened to my coffee?
To help avoid due process liability risk for you and your entity, you must follow these quasi-judicial rules of engagement. Don't make up your mind before the board or council hearing on the application. Just like a judge, your obligation in a quasi-judicial proceeding is to decide the case through your council or board's deliberation based on the evidence presented to you at the hearing. Don't make prejudicial pre-hearing statements. Just like a judge, you should not announce how you would vote on an application or make comments for or against an application before you've heard the evidence.
Oh man, Carol, have you seen this application? I will never approve this.
Don't engage in any communications with interested parties outside of your board or council hearing. These are called ex parte communications, and engaging in them can be a sure path to having the integrity of your process questioned and your decision challenged.
Hey, Councilman Jones. Yeah, what you told me last week was absolutely right. Everyone I'm hearing from hates these applications. Everyone. I told my mailman. He hates it.
Insurance claim, that's going to cost you. Don't participate in a quasi-judicial proceeding in which you have a financial or personal interest in the outcome. If you have a conflict of interest in a matter pending before your board or council, you need to declare your conflict and recuse yourself from the discussion and vote.
If these condos get built, it will ruin the view from my wife and I's master bedroom. I gotta make sure these things never get approved.
Also, don't be a witness in your own quasi-judicial proceeding. Instead, have the parties provide your board or council with information during the hearing. Remember, as the judge in a quasi-judicial proceeding, your job is to consider the evidence and testimony that others present to you, but you should not be offering your own evidence.
I actually photoshopped what I think it will look like if they build them, and I hate it. Here, I'll email it to you. Yeah, I did that myself. No, I don't want to see the buildings. I want to see the mountains. I want to see the deer feeding and the streams.
That's illegal procedure. The due process rules of engagement can be complicated and can sometimes seem at odds with the general expectation that you or your citizens may have about interacting with elected and appointed officials. But following these rules of engagement is critically important to ensure fair process and avoid the risk of a due process claim. Make sure you get further training on how you are to conduct yourself in relation to quasi-judicial proceedings, as liability consequences for mistakes in this arena can be dire. At CIRSA, the most common situations we encounter that raise the possibility for individual and personal liability for an elected official are those where the elected official really didn't have the authority to act on their own. Within the framework of your town board or city council, pretty much everything you do requires collaboration. Apart from the few duties vested in the mayor, the laws governing cities and towns don't give any powers to individual council members. That's why being an elected official is a we job.
Attorney, manager, judge, I know all of those guys. Hands down, please. I have changed a few things. City council, but no questions, please. Wait until I'm done. This is my time up here. All right? Honestly, I might redraw this, put a little box up here that's me and then the city council, because I am part of the city council, but everybody knows that, I kind of am the city council.
That's illegal procedure. When you're part of a multi-member governing body, it's certainly important to bring your own views, ideas, and goals to the table, but elected officials can't get anything done as individuals. You can only accomplish your goals by working together. And that's why you'll have to work to build consensus within your board or council.
Okay, so let's hear some ideas.
We need to let the city manager hire more staff.
Hire more staff, absolutely. We should get moving on that right away.
I think we need to provide more support to the employees.
Of course, we'll support them. We'll hire them. We'll support them. Love it. This is great. Great ideas, guys. I love you guys. We should hang out more. Can we get a high five chain going? Huh?
Liability-wise, striking out on your own and attempting to exercise authority you don't have is never an option. That can result in allegations that you're acting outside the scope of your duties as an elected official. And that type of go-it-alone conduct can even imperil the protections from liability that you have under state law and your public officials' liability insurance. Those protections, which are designed to defend and pay claims against you, apply only when you're acting within the scope of your authorized duties. Fortunately, Colorado is a state with strong liability protections for public officials and employees. For one thing, we have an excellent Governmental Immunity Act that provides certain protections against civil liability. But to retain those protections, it's important that you stay within the scope of your authority and not act in a willful and wanton manner. and seek guidance as needed to ensure you're staying out of harm's way. Like every organization, everyone within a public entity has a job description, and it's important you understand and stay within your job description. For elected and appointed officials, your job is being a member of the legislative and governing body of your city or town. In this role, you're responsible collectively with your fellow elected officials for making laws, handling governing body level policy, planning and financial matters, adopting the budget, and approving long-term plans. You're also responsible for handling those corporate affairs of your organization that are appropriate to the governing body level. In contrast, many of the day-to-day tasks of running your municipality are the responsibility of your staff, including your city manager or town administrator, if you have one. Other powers and duties are by statute or ordinance assigned to specific officials, such as the law enforcement duties assigned to your police officers or the election responsibilities assigned to your clerk. Liability-wise, you'll want to honor these allocations of responsibility and not get involved in administrative, personnel, or other tasks that are assigned to staff. You'll want to resist the temptation to micromanage projects. After all, your job as a member of the elected body is to identify, prioritize, and fund your municipality's projects and initiatives, but not to manage them day to day. In our experience at CIRSA, it's in these areas of administrative and employment matters where personal liability risks can get heightened. In worst-case scenarios, we've even seen individual elected officials face allegations of defamation, retaliation, or other bad acts, and no elected official relishes the thought of getting ensnared in one of these types of claims. What are some of the steps you can take to avoid these potential risks? First, don't act on the basis of personal motives or self-interest. When an official gets ensnared in one of these problems, it's often obvious upon reflection that the official was not acting in the scope of their authority and was acting just to even some personal score or obtain some improper advantage.
Yeah, make sure to get under, like in the undercarriage, because a lot of crud builds up in there. I had to cut through a field on the way over here. Bunch of trash and you'll see. Yeah, right under there. Hey, could you pick it up a little bit? I'm supposed to go to the movies after this. Council members get in for free. Technically they don't, but I make them let me in.
Council member.
Look, I don't know what any of this is about, but
one word.
I deny all of it, okay?
Council member, is it true you ordered Public Works to wash your car in the City Hall parking lot?
Is it true what? No, I would never do that. I like to wash my own car. I do it all the time. I did it today. 3 times.
Second, responsibility for personnel issues should be assigned to your city or town administration. The governing body should be focused on the major legislative and quasi-judicial issues and leave administrative matters to staff.
Well, but we need to get to new employees that contain all of our policies.
Hey,
all
new
of our
guy.
procedures.
So every day you come in, you're going to see one of these on my door. It's going to change every day, but this is the one for today, okay? First one, pick up dry cleaning. Pretty self-explanatory. Next, wash my mom's car. Not my
Councilman,
car. My car's
please.
taken care of. Buy dog food.
There's
It's
no
easy
way
to
he's
find.
asking me to
Big
do
bag
this, right?
has a dog on it. There is one with a cat on it. Don't get confused. I'll get angry. Set up online dating profile. Need one for me, one for my mom. We can't keep sharing one, okay? It's getting weird.
That's a foul! Third, never retaliate against someone for exercising their legal rights. Not only is retaliation against the law, but retaliation claims are among the most difficult and costly to defend.
Hey, good morning.
Is it a good morning? My mom's car is still filthy, you know? She's not doing great on any of the dating sites.
Insurance claim, that's going to cost you. In summary, you have excellent personal immunities recognized by our courts when you're acting on legislative and quasi-judicial matters. However, you do not have strong immunities when dealing with administrative problems. That's a good reason to not get involved in personnel and administrative matters that are outside your role as an elected official, and to instead honor and support your city or town's organizational structure. As an elected official, it's important you understand that you and your fellow board or council members hold important and powerful positions in your local government, and you'll want to use that power wisely and humanely. We've all seen bad situations unfold in the news, and while the reaction is usually, "That will never happen to me," such high-profile incidents are a good reminder that public officials should never try to put themselves above the law or try to get some sort of special privilege because of their position. In terms of civility, it's important to understand that as public officials, the way you conduct yourselves in meetings and other public settings sets the tone for your entire organization. In your leadership role, your words and deeds carry a lot of weight.
Dave, good morning. Hey, listen, if you tell anybody about me parking in this handicap spot, that could be bad for you. I'm serious. Have a good day.
A harsh or ill-considered comment from a public official, especially if made in public, can be extremely harmful to your organization's reputation, to your employees' morale, and to your public image, and can even give rise to liability situations. Civility and mutual respect can go a long way in avoiding these problems, and we at CIRSA have observed that public officials do their best work with least risk when they commit to civility and respect with each other, their staff, and their constituents. As this video suggests, there are a number of best practices you can follow to ensure success and reduce your liability risks as a public official. These include: commit to openness and transparency. Think and act in terms of we, not I. When acting in a quasi-judicial capacity, be fair and impartial. Don't make up your mind before the hearing. Base your decision on the applicable law and the evidence you hear at your public hearing. Don't participate in a hearing or the decision if you have a conflict of interest, and don't engage in any ex parte communications. Refrain from personal or retaliatory actions. Focus on the key legislative and policy issues facing your organization, and leave administrative matters to staff. Maximize your liability protections by staying within the scope of your authority and avoiding willful and wanton conduct. Again, congratulations on your election or appointment to public office. Best of luck, and thank you for everything you do for your community. For more information on CIRSA suggested best practices, visit the CIRSA website or contact CIRSA Membership Services.